Hi, Jim Sobach. Today I'd like to take a couple of minutes to talk about the exceptions to the automatic stay. So Section 362A rather, of the code says what creditors can't do. 362B says what they can do. And we've already talked about 362A. So what are some of the things that creditors are permitted to do? That is, things that are not stayed. There are 28 separate exceptions, and I'm not going to go through all of them. I picked the ones that are the most common, the ones that we see in cases. A lot of these other ones, you know, I've been doing this for many years. I've never seen them, but here are some of the major ones. The continuation or commencement of a criminal proceeding. And usually this comes up in a bad check scenario. So you have a client wrote a bad check to a creditor, files a bankruptcy. Is that debtor protected from criminal prosecution? I don't think so. Now, I spent a lot of time researching this because I had a case on this, and this seems to be the law, that first of all, you have to understand, because of this, there is no stay. So if there's a criminal proceeding that started pre-petition, that can continue, or the creditor could go right down to the DA's office and file a complaint. There's nothing that stays them from doing that. Now, what some debtors' lawyers have done is said, okay, yes, there's no stay, but I want an injunction, Judge, to prevent them from doing this because they're just using this as a collection efforts. And early in the cases, that was kind of successful, but a lot of these cases went up to higher federal courts, including the Supreme Court, and basically the courts have said, you know, a federal court really doesn't have jurisdiction to come in and restrain a state court criminal proceeding. So if you have a client that wrote a bad check, I don't think I'd be telling him or her that they're, you know, immune from criminal prosecution because of this. Child support obligations, maintenance obligations, dramatic change in 2005 with BAPSIPA. Way too involved to go into detail here, but let me tell you that many of the things that were stayed prior to that are no longer stayed. And one of the things we see a lot of is, let's say you have somebody, they're behind on their child support, you put them in a 13, you're going to pay the arrears through the plan, you're going to maintain the payments, you think, okay, we're covered. And traditionally you would be. But because of this, a lot of the things that the support obligation people could do, or could not do, they can now do. They can restrain bank accounts, they can garnish wages, they can take the driver's license, even though the arrears is being paid through the plan. So this is an exception you really need to be careful of. The certain liens can expire, okay? And you have to renew them with the court. This is not allowing a creditor to create a new lien. It allows them to renew it. So for example, a UCC statement filed before the bankruptcy was filed, it's going to expire. They can go down and with a county clerk and renew that. It's not a violation of the state because they're not getting anything new. They're just protecting their interest. Tax liabilities. Obviously, they can't collect the tax, but they can perform an audit. They can create new assessments or charges based on filed returns and based on audits. But one thing that they can demand that you produce your tax returns, which the code already requires. But one thing that throws people is this one right here. They can send a notice and demand of payment. So we get this all the time because the New York State Tax Department does this. And your client may get this thing, notice of tax due and demand for payment. And you look at that, well, that's a clear violation. No, it's not. Now, can they actually collect it? No. And, you know, I wish they didn't use this language because the debtor sees this demand for payment. You're demanding that I pay? I thought I was protected. It's just a notice and they can't do anything with it, but they can send it, and the New York State Tax Department, in fact, does do that. If your client was in a lease and was in an eviction process, if there was a warrant of eviction before the bankruptcy, there's no stay. They can just go ahead and evict your client. Now, if the warrant hasn't been issued yet, they have to make a motion for relief, obviously, and then get the stay lifted. So those are the main exceptions to the enforcement of the automatic stay.